certainly strengthened by the 3 justices appointed by President Trump, now are making history in every term, and they see their power, they're using their power.
Well, I think a lot of this comes down to context. And so, for example, in the student loan piece, I think what the court was doing on the separation of powers standpoint is saying that really the decisions here are made by Congress, which has a broader electoral base and representation of interest than the executive branch. And so if the president is going to use a statute that was put into place for modest waiver of in circumstances where there's an emergency and originally was used in favor of military personnel, that is not, that's beyond the congressional authority that was given. And so it's time to go back to Congress if folks would like, there to be different policy options. And then I think for the decision yesterday, the court saw some concern with, particularly in the case of Harvard, actually some perhaps discrimination against Asian Americans. So one group and not wanting there to be people favored just on the basis of race. As far as the court making history, I've been at a conference this week where a top Supreme Court advocate actually was giving some statistics from this term. And interestingly, at least as of yesterday, had found that Justice Thomas and Justice Alito were actually more in dissent this term even than Justice Kagan and Justice Sotomayor, which might be somewhat surprising. But statistically, if you look across the board at some of the decisions this term that have not been in favor of the business community, and then the voting rights decision the other day, it actually appears that Thomas and Alito have been in the minority more than some of the justices who wrote dissents today.
But that's partly because they were doing the less controversial decisions up front earlier and were clearly divided and arguing back and forth in different, trading opinions, draft opinions back and forth, and leaving these 2 most important ones, arguably. Voting rights surely was, and Justice Roberts, the chief, certainly weighed in on that. But clearly leaving these 2 for the end. Barbara McQuaid, let me ask you about the web designer decision, because there's a lot of suggestion today that, alluding to what Justices Alito and Thomas in particular said at the end of the Dobbs decision, that this could be interpreted more broadly beyond, the websites.
I think that's right. And if you read Justice Sotomayor's dissent, what she says is absolutely true, that today the court relegates the LGBTQ community to second-class status. We've seen over the history of the court that they would not tolerate these kinds of discriminatory acts against people of color, not against people of religious minorities. But when it comes to LGBTQ couples, then this belief that these marriages are, quote, false is enough to trump that right to public accommodation. It really jumps out to me as just as Justice Sotomayor says, not just wrong, but profoundly wrong. And the concern is now it's open season. Anybody who has a business who doesn't want to serve gay couples or gay individuals can just say, I'm going to cite the 303 creative case. I'm going to put up a sign that says no gays allowed. She cites the history about signs that used to say no dogs or Jews, about how Jackie Robinson couldn't stay with his teammates in hotels in the South. That is now fair game when it comes to members of the LGBTQ community.
And, of course, handicapped or disabled people are also, in the crosshairs potentially. Do you think, Barbara, before I let you go there on this subject, do you think Oberfelder could even be in play? Gay marriage?
I do, only because of what, as you mentioned, Justice Thomas said in his concurring opinion in the Dobbs case, which was that anything that relied on substantive due process was fair game. And if you read Dobbs, even though the majority was quick to say, no, this is strictly limited to this issue, but the basis for it was to say that there is not this fundamental fairness substantive due process right. And so any other right that relies on that, and one of them is same-sex marriage, I think it is fair game if the court wants to take it up.
And Laura Jarrett, you were this morning alluding to the fact that there was another gun case for spousal abuse cases, and they have now taken that up. Do you want to explain the significance of that?
Yeah, that could be a big one. At the end of the term, they do sort of a cleanup order, if you will, and it has a list of the cases that they're going to hear for next term. And one of the cases on there has to do with the federal law that had said people who had restraining orders for domestic violence shouldn't have firearms. Well, the Federal Circuit Court said, no, that's not okay under Supreme Court precedent, and they struck it down. So they actually gutted the federal law. The Justice Department, as you might imagine, appealed that and wants the Supreme Court to put the law back in play. And now the Supreme Court has taken it up, which, given the Supreme Court's rulings when it comes to the Second Amendment and guns, I think is raising a lot of eyebrows about what exactly they would plan to do here. Now, maybe they would uphold the rights of gun owners to possess firearms even after they have a order for domestic violence, or maybe they wouldn't want to go that far and they would say, no, we're actually going to make sure that that federal law is restored. So we'll see what they do here, but certainly yet another big case when it comes to fundamental rights, when it comes to the Constitution, when it comes to violence against women. It will be a big case to watch for next term.
And Jenn Psaki, this is another case. Guns is such a hot button issue on the right, Second Amendment rights.
It's also become a hot button issue on the left and among independents as well. And as I listened to Laura describe that case, I mean, do you think a person who's a domestic abuser should have access to a firearm? It almost seems insane to say, yes, you should. I'm not a lawyer, so I'm not giving legal analysis there. But the challenge the Supreme Court has is that some of these decisions have dramatic impacts on people's lives, and they just don't sound right or sit well with people across the country.
And to Danielle, I mean, is there an issue here where the court has to begin to worry about the respect? And, you know, they're not running a political campaign or a popularity contest, but they need to be observed. Their rulings need to be obeyed. And that requires the broad electorate. You know, that America really respects what they're doing.
Yeah, I think institutional accountability and institutional credibility is really at issue for the Supreme Court. We see their approval ratings in the 30s, and making decisions that have such a negative impact on the lives of everyday people, especially when you begin to overturn very longstanding precedent, like what we saw them do in Dobbs in the reproductive rights case last year, and then yesterday in the affirmative action cases, in which that was essentially a 45-year-old precedent that was wiped away. You have to really consider what is the institutional significance of what they're doing, and also with all the ethics questions around the Supreme Court. I think that those two things put together, the overturning of longstanding precedents and the ethics questions, begin to raise the specter that the Supreme Court is dragging us back 50 or 60 years and wondering what is the limit to that, especially again today when you see these 6-3 opinions in really important cases. It just calls to mind all of those important institutional questions.
Jennifer Mascott, what about the issue of confirmations? Because in all of their confirmations, they all said that they would observe precedent, stare decisis. And now you see them in Dobbs and then in the affirmative action case, clearly going against precedent.
Well, I think what's interesting, actually, in the distinction between the Dobbs majority opinion written by Justice Alito, joined by only 5 in full and reasoning, versus the 6 justices joining yesterday in the opinion written by the chief, is that it does seem to me that the chief, he declined to expressly say that Grutter was overruled yesterday. And also Grutter itself suggested that there might be a change in 20 or so years, which is where we are currently. So I think at least my sense, reading between the lines there tactically, is that the chief might see the court as having treated precedent a little bit differently this year and not expressly overruling something. To go back to the wedding cake case, I also think it's really important there to really look at the contours of the holding, which I think the justices perceive to be fairly modest, because Justice Gorsuch starts by actually saying that the wedding cake designer explicitly confirmed that she'd be willing to work with people, obviously, of all backgrounds and not discriminate, and that here it was really important that everybody in the case conceded that expressive activity was at stake. And so what the court was finding to today is that the First Amendment means the state cannot compel somebody to create a product that has a message that differs from their religious beliefs. Just like the court in the past has said school districts can't make children raise their hand to the flag, we wouldn't say an atheist has to force somebody to convert to a religion they don't believe in. Here, the court is saying, in this case, we're not going to require under Colorado, allow Colorado to require this wedding cake designer to have to create these messages, but she will serve all people to the best that she can.